Hello, everyone. Today we are interviewing Professor Burkhard Schafer, which is a professional of computational legal theory at the University of Edinburgh. He just gave the Max Weber lecture yesterday. My name is Rafael. I am a Max Weber Law Fellow in Law.
I'm Filippo, also Max Weber Fellow in Law.
And yeah, let's get started. So, Professor, the first question would be, how do you define computational law? How is it distinct from legal tech more broadly? And if you could walk us through an example.
Yeah, so I would say legal tech is applied computational law in many ways. It's where we try to have impact with our research, make a real difference. But computational law and computational legal theory is much broader than that. People were thinking in terms of computational metaphors long before there were computers. We have the idea of mechanical jurisprudence in the 19th century. The idea of the judge being the mouth of the law and nothing else. We have Metri, man as machine, all of that long before we could even dream of implementing it. And that is all part for me of computational law, thinking of law in computational terms, whether or not that can be implemented with today's hardware. That is one of the big differences. The other difference, I would say, is if you look at what is described as legal tech these days, quite a lot of it is relatively mundane back office technologies, invoicing, case management, things like that. And to be honest, I do not see them part of academic concerns with computational law. They are important for practice, but they do not raise the conceptual issues that computational law deals with. And at the same time, there are technologies that are really interesting, but are not made by lawyers for lawyers and still could have transformative capacity. So this morning during the masterclass, we talked about automatic translation. We do not normally see that as a core legal technology, but it can have transformative potential for the legal system. And with that, I think falls within my remit. Talking you through an example, I can tell you something about a project we had recently about autonomous vehicles. We want autonomous vehicles to abide by the law. We have the known alignment problem between AI and humans, that they sometimes have weird ideas about what should be prioritized. And we want to make sure that autonomous vehicles adhere to the law. And indeed, the UK legal framework says autonomous vehicles are permitted on UK roads if they adhere to road traffic laws. And one obvious idea then is to take road traffic law and translate it to something that becomes intelligible to the car. After all, that is how we train human drivers. You have to pass your theory test in addition to your driving test. You have to show at least some basic understanding of what the Road Traffic Act demands of you. So it seems to be plausible, at least, to think of cars as a new audience for legislators, new audience for lawmakers. And there are several projects going on all over the world that try to turn road traffic law into typically a rule-based, prologue-based type of system to ensure the car will always adhere to road traffic law. The moment you start thinking about it in these terms, you also realize that can't be quite right, can it? Yes, it's true. We teach young drivers about road traffic law, but we don't do that at the point of application. Every driver knows I have to stop at a red traffic light. But if I ask them, which section of the Road Traffic Act did you just abide by it? I have no idea. I just know I have to stop. So that gap between having explicit knowledge of the law and knowing how to behave lawfully is exactly one of these questions we try to address when we ask ourselves, what does it mean to turn law into computer code? And with certain things, it was easy, like stopping at a red traffic light. And that seems to be totally straightforward. But then we had a rule that says the driver of a vehicle must not be drunk. How do you turn that into code? Is it even necessary to turn that into code? Can autonomous vehicles be drunk? Or could we simply make the decision that law doesn't apply? If so, who makes that decision? So there were lots and lots of methodological questions we had to ask ourselves before we even started coding. And that is for me really important. You should think hard and deep about the methodological choices you make, the technical choices you make before you write the first line of code. And once you are clear in your mind what you are doing, you can then start to push that. One section of our Road Traffic Act says you must drive with reasonable care if there are children, pedestrians, cyclists, and parked cars. Well, if there is a likelihood that there are pedestrian, cyclists, and parked cars. There's a very straightforward way you can formalize this as a simple conditional, if A, then B. If there are these things, then drive more carefully. That's a valid formalization. It's not computational. It is also totally useful. It doesn't tell you when you have to drive carefully. It just leaves all of that still to the human operator. So we need to unpack that more. We can ask ourselves, is the end the right formalism here, or did the legislator mean something else? Arguably they did, they meant an or. Who makes that decision? Is it the developer, an engineer, or a car manufacturer? Do they have to get sign-off from the law department? Again, methodological questions. Then we had to start to think about terms like the likelihood of a pedestrian being nearby. So it's not enough that the sensors of the car spot a pedestrian. That's the easy part. They have to reason about, even if I don't see a pedestrian right now, how likely would it to be someone suddenly stepping in front of me? So that term of likelihood in itself lends itself to lots and lots of different formalisms that we could use to unpack it. Reasonable care, what does it even mean? And then you get something that looks like a straightforward rule. Do not drive faster than 60 miles per hour. Is it a good idea to program that into an AV? I would say no. Why not? Now imagine it is 2 o'clock in the morning in the Scottish Highlands. Your best friend just suffered a heart attack. The next hospital is 100 miles away. There's empty road all ahead of you. Chances that you hit a human, nil. Chances that you hit a sheep, 2 or 3%. What every responsible person would do at this point is to say, I don't have to adhere to road traffic law. My obligation now is to save my friend. The law doesn't apply. I can make the decision that the law can be set aside. And one of the interesting theoretical questions for me is, when and under which conditions would we allow the car to make that call? When do we allow them to be civilly disobedient? When do we realize that there are higher values that allow us to deviate from the programming? So all of that are things we have to consider. And for me, the fascinating thing is it starts with something that seems to be extremely simple. And as you progress, you suddenly realize law is much, much more complex than I thought. And you also get a better understanding of what the law is as an outcome.
Thank you very much. Now, let's bring legal education into focus. Has the way we teach and learn law, we conduct legal studies, has it adapted to computational tools, to legal technology at large? And to what extent? What are your thoughts on this?
So what we've seen over the last 5 years or so is that we get more and more courses of coding for lawyers offered by more and more universities. Edinburgh used to be one of the first, and for a long time the only one, because that was me. For the last 30 years, we were running a master course in AI for lawyers, but that was the exception. These days, you find entire programs in AI and law, legal tech, and you find more and more coding for lawyers courses. And I'm massively skeptical about whether they are value for money. And that is partly my own biography. When I was a student in the 1980s, they told us more or less, there's no point in studying law. AI is there. This is 1980s. AI is there, and by 2000, there won't be any lawyers. Richard Susskind's book, The End of Lawyers, was written at about that time. So we were told more or less, be really careful. Law might have reached the end of its useful life. You all need to learn how to code. And I took coding for lawyers courses when I was an undergraduate. That was probably the worst waste of my time that I ever did. And I work in that field. I learned some arcane programming languages that were cutting edge at the time. I can, in theory, I think, still program in COBOL. I don't think I ever needed to do that. And I work in legal tech. So the danger that we jump on the latest bandwagon and teach a specific coding paradigm, which will be obsolete by the time you're graduated or by the time you work, is massive. We also see increasingly low coding or no coding platforms being commercially open. So these days you can build quite sophisticated systems without being a coder. So that is for me not the right way. The way I would teach that aspect is as part of legal theory. Because what legal theory asks, jurisprudence asks, classical question of jurisprudence is, what is the law? What does it mean to have legal knowledge? What do we do when we actually make a legal judgment? It's a descriptive jurisprudence, and we have a normative jurisprudence. What is good law? What do we expect from a good justice system? How should the law operate? And you can tweak both of these aspects and turn them into an introduction to computational law for lawyers without them even realizing that they are trained to be legal technologists. The classical philosophical problem, what does it mean to know the law? What do we know if we know the law? Becomes translated in a knowledge representation problem. How do I represent legal knowledge computationally? What are the abstract structures that I need? So I think a knowledge representation paradigm, something that is linked to jurisprudence, is much better suited to prepare in a flexible way to the future than a specific coding language. Then there's a second element to that. And that is totally different, almost the opposite approach to coding for lawyers, or even computational thought in jurisprudence. And that is to say, there are certain things we value in a good lawyer. Again, it's a jurisprudential or an ethical question. There are certain things we want to see in the wise judge, in the competent advocate, that are much less likely to be replicated by computers than other fields. Deciding how much taxes someone has to pay. Yes, I think there are relatively straightforward computational representations. Consoling a distressed victim of a crime so that they can give evidence in court in a way that convinces judge and jury is a totally different skill set. Advising people through an adversarial divorce. My mother has a PhD in family law, international private law, as a specialization of family law, and she practiced a little bit as a lawyer afterwards. And she said, nothing that I learned as a law undergraduate or during my PhD prepared me for what I had to do in practice. I would have been a better family lawyer by studying psychology, by studying communication theory than law. The law I could have learned on the job. That was straightforward. The difficult part was to have someone sitting in front of me whose life is falling apart, who can't think straight, and explain to her what I need to know from her to turn her lived experience into something that is intelligible for the law. Totally different. And I think there, as lawyers, we struggle, especially in Europe. American law schools, with their greater emphasis on practice, are sometimes a bit better. But unlike medical students, we do not teach bedside manners. If you are a medical student, you are getting trained in how to talk to a patient. You are trained how to talk to someone who is in pain. We do not teach lawyers that, and I find that as scandalous, personally. So I would say maybe the better response to the technological disruption and digital law is not to trying to compete with computers, they outperform us probably, but to specialize and focus on the things where we add values as humans. And that would be the soft skills, empathy, emotion recognition, appropriate communication strategies. We teach way too little about that. Continental Europe worse than the UK worse than the US. I think we really need to learn also from medicine in that respect.
Thank you.
Okay, so following up on that, actually, I think one of the things that are frequently brought up when talking about AI is the issue of labor displacement. And I think one of the main responses that are given to people who are worried about labor displacement is job creation. So do you think that there will be new jobs being created in law, but also on the other end, there will be also some kind of resistance in certain areas of law towards automation? So two types of reactions to labor displacement would be resistance and job creation. Like, what is your thoughts on that?
I think, yes, we will definitely see both. I mean, one historical lesson we have is technological unemployment. It always tried to predict the future by varying one parameter and keeping everything else constant. There's a fixed number of jobs. That section will disappear. Therefore, we'll have overall fewer jobs. I think we discussed it yesterday in the context of autonomous vehicles again, or vehicles in general. The prediction in 1910 or thereabouts that by 1950, all our major cities would be covered in horse dung, because the number of people living there and the number of horses they were needing was ever increasing. This is not how the future works. So yes, I do think there are potentially new jobs that are getting created. I think that there is lots of advice you can give that is not necessarily legal advice as traditionally understood, but advice that sometimes draws on legal resources. Sort of life coaching plus, if you like. We do not want to legalize everything. We should not think of all our relations in legal terms, but there is, I think, a mix you can sometimes get. And I think in the commercial field, many multidisciplinary partners already do that. They do risk assessments, they do estate planning, they do things that go beyond traditional legal advice. And I think we will see more of that. In a way, almost by definition, we can't predict what these jobs are going to be, because if we could, then we would already have them. But there might be a very different way in which lawyers become part of engineering in the Internet of Things. Diagnose that certain systems are not working as expected, working hand in hand with an engineer to say, I evaluated this smart grid application and, yesterday there was this blip, and that is a legal blip. It is a GDPR violation, technically speaking. So we might see that. We might get totally different, weirder and weirder ideas. We might get advocates for misbehaving robots, psychiatrists for misbehaving robots. Depends on how very much in the future you are willing to look at. So that is definitely a possibility. I think in the near future, and that was, again, something I mentioned in my lecture, we need to think of computing as a profession. We need to bring them under the umbrella of the professional legal organizations. We do that in Scotland through the accredited legal technologists. It's now possible for someone who doesn't have a law background to become regulated by the Law Society of Scotland and a member of the Law Society of Scotland. I think that's an important step. What we've seen often, especially when we discussed that amongst us with the Law Society and big law firms, there was often no good career path for technologists in law firms. The law firms treated them like IT support. The people you call when you forgot to plug in your computer screen and who then tell you, oh, that is what you have to do, or this is how Zoom works. And you very quickly reach a ceiling of competence and money you get. You don't have a pathway to become anything equivalent to a partner, for instance. So I think we need new career paths within law firms for people with a technology background, and to a certain extent. I think we can see that slowly happening, and I think it's an important step to do that.
Thank you.
Before wrapping up, let us address directly our Max Weber colleagues with a question about or your thoughts about academic careers and also some of our existential questions on how to proceed. As early career researchers, we experience the opportunities and the concerns of finding our own way in academia. So throughout our Max Weber journey, we engage in book proposals, in articles writing, we start new projects, but also we apply for jobs. So we are in very uncertain times. Do you have any special advice or suggestion for early career researchers as we are as Max Webers to find their own way and navigate the uncertainties of the academic career?
I am so the wrong person to ask that question, I'm afraid. I mean, I sometimes, for funding applications and for appointments to official committees, have to write a short CV and bio and explain what I did. And I sort of managed to make it look as if I had planned this, but this is all a lie. I mean, this is honestly just a lie. If you look at it objectively, I have a MA in Logic, Theoretical Philosophy and Computer Linguistics from the Ludwig Maximilian University in Munich. My parents were lawyers, both of them with PhD. My grandfather was a lawyer with PhD, and I think his father was as well. So when the question came up, what do you want to do with your life? The one thing I knew was, I'm not going to become a lawyer. Definitely not. I mean, that's the last thing I want to be. I do not want, so I went to my parents and I said, I don't want to disappoint you, but I decided to study philosophy. And my mother said, oh, son, of course, we will support you in all the life choices you make, as stupid as they are. There's only one part of the deal I have to insist on. If you want to study philosophy, then I'll teach you how to cook, because you will have to marry a wife with a proper job sometime. And that was the deal, and I still cook passionately, even though I eventually got a job, but I definitely didn't plan to get a job in law. That was the absolutely last thing I had on my mind. And it was then ending up in Munich after studying at some other places, more by coincidence than by design. And there the idea was, if you want to do theory of science, if you want to do computer linguistics, you need a field of application, choose one. And because all of my contemporaries did biology, physics, mathematics, I went for law simply because I wanted to do something slightly different. That turned out to be quite good. But again, it wasn't planned. My plan was to become an academic in philosophy in Germany. And then I applied, yeah, I applied here in Florence for a, wasn't a Max Weber thing at the time, a master, 1-year master. And I was shortlisted for interviews, and then I had a rather stressful interview where the interviewee said, what on earth are you doing and why are you here and you are not a lawyer, go away. And I went away. I went 20 miles further south and I did my Erasmus year instead at the University of Florence in the philosophy department, but with mathematicians, Enrico Cantini and Maria della Chiesa. And they were eye-opening because they introduced me to philosophical ideas that were totally new to me. So the best thing in a way that happened to me was not getting accepted here. Sorry to say that, but this would have left me on a career path, pretty fixed. And that suddenly opened up totally new opportunities. And then we had the AI winter. And suddenly all the funding had disappeared. And there was not jobs for programmers. And at that point, someone in Florence down there said, look, you teach law to computers. I can tell you from my experience, your average undergraduate is not cleverer than a computer. If you can teach it to a computer, have you ever considered teaching it to lawyers? And I thought, I never considered that. This is a fascinating idea. Think about it. We as lawyers, we are crisis safe. If the economy is good, we do mergers and acquisitions. If it tanks, we do insolvency. There will always be a job for lawyers. You've done already a lot. You've learned how to teach it. just do some law degree. And I went to Lancaster, got a scholarship there again, more by accident and then by design. And I was lucky that when I arrived there, 3 people that were supposed to teach me had left, and they desperately needed someone to teach German law. And I thought, oh, I can do that. So I did that as part of my master degree there. And my students liked it, and I liked it. I realized I enjoyed it. But I still thought at that time, oh, this is a nice diversion. But I have to go back. I have to go back to Germany. I have to do a PhD in philosophy. I have to become assistant to a professor for whom I will work until I'm 50 and publish under his name. And then if I'm lucky, I might get a job. My supervisor in Lancaster said, don't be stupid. You're good. Just apply for jobs. Can't do that. I have a master in philosophy. How can I apply for jobs? And trust me, Burkhard, just trust me, put it around. And I applied for lots of jobs, got lots of rejections. And then was really lucky that Neil McCormick got elected to the European Parliament to write the European Constitution, and he needed someone to teach his new course in law and AI. And I was interviewed, and after the interview, I was 4th on the list. And then something terrible happened to 3 people ahead of me on the list. Did I mention I taught forensics as well and crime scene investigation? Yeah, so something happened to the other people ahead of me on the list, and suddenly I got this job in Edinburgh, 2 years teaching replacement for Neil McCormick. And after the 2 years, they said, look, we like you like us, why don't you stay? You couldn't plan for that, is the short answer. I couldn't plan for the AI winter and funding drying up. I couldn't plan for moving from philosophy to law. None of that was intentional. So in that sense, I'm a bad person to give career advice, apart maybe from the one not to believe that if you don't get an opportunity, that is the end, and you now have to regroup. As I said, one of the best things was not to get the scholarship here. Be open to other opportunities. Think about what you could do, even if you are not planning to do that. So for me, that flexibility matters. In more practical terms, I mean, as I said, this is not very helpful for young academics, and I appreciate that. You also face a difficulty that different departments, different intellectual traditions follow very different rules, and that different countries and their educational system follow very different rules. When I applied in the German universities post-Brexit with my rather weird UK CV, you could say, look, I'm a full professor. I have a 12 million pound research project that I lead. I created a new master course that is heavily oversubscribed. Could you please give me a job? And they looked at my CV and said, here's your first state exam. And that was the end of it, typically. So I had probably closed down at that point doors. And I think as a young career academic, you need to keep a little bit an eye on what are the different requirements in the countries that you are considering, because they will differ significantly. Even within the same university, I'm sitting on job appointment panels in computer science and in law. The things they are looking for in the same university are massively, massively different. You talk about book proposals, for instance. In computer science, they do not care. They even don't care about articles. They want to know which of the A-graded conferences do you go to? What is your conference community? And the second question they ask you, how big do you want your lab to be in 3 years' time and how you want to pay for it? Much, much more important than anything else. So unfortunately, you need to have some awareness of what might be relevant within that space that you are considering. So that's one thing. The other thing that I realized, and again, that's partly because my own trajectory was a bit unusual. I didn't do postdocs. I didn't do research focus jobs at all. I was pretty much thrown in at the deep end of teaching from day one. And not only did I enjoy it massively, I also benefited massively in my research. I couldn't have done half of my research or 80% of my research without my students. They are my lab rats. Every idea I have, I try out on them, and most of them have survived and thrived, and we're not talking about those who struggled. Talking to them, explaining it to them, inviting them in. I also publish with them. That also happens. I had a lot of my papers are jointly done with my students. But simply the challenge to turn my vague ideas into something that works for this audience has tremendously benefited my writing. So for me, an important advice, therefore, would be to say, do not separate teaching from research artificially. Do not treat teaching as a burden that you try to avoid because you think you have to focus on research. Yes, it seems as if the only thing that matters are your publications. It seems as if the only thing that matters are your grant applications, but you will get better at these if you teach well. So that would be one important lesson that I learned this way. You make your own life easier if you keep these two aspects of an academic life together. Networking is important. Interdisciplinary work can be massively rewarding, but you are also still running against institutional boundaries. It has become better than it was when I started. There are more interdisciplinary journals out there. There's more funding available that is interdisciplinary, but it still can be difficult. I still get rejections for papers where I'm told the content is probably nice, but in our community, the convention is different. You can't just write about the program without giving me specification on the runtime or something like that. Can be frustrating, is getting better. Again, the small piece of advice, if you want to go into the legal tech direction, there is an opportunity and a danger. So the opportunity is that more and more university systems, more and more funding bodies have realized that we can't let these scientists and technologists unsupervised. They need looking over and after. We want legally responsible AI, that's the AI Act in Europe and other design-centric things, GDPR, data protection by design, gives lawyers a standing now, a stake in technology development that didn't exist before. So we are suddenly sought after. And I probably get these days about 3 or 4 invitations to join quite well-financed research projects led by informatics per year. And most of them I now reject. And why? Because if I look at them, I realize they do not want me as a researcher. They want me as a service provider. Mm-hmm. I'm not going to learn anything from that project. I'm going to teach them basics in law. I'm going to sign off on their data protection plan. If they are really, really irresponsible, they just want to save some money hiring some proper lawyer and want me to do their commercialization for them. And I said, sorry, I'm a researcher. Don't abuse me as a cheap alternative to a practitioner. And that is a real danger. I see that a lot. Having said that, it was a good way to get my foot into the door. So the very first research grants I had were led by informatics. My own research contribution was a bit more limited. I often just provided domain knowledge. The main intellectual achievements were on their side, but they got to know me. They got to trust me. We started working relationships. Trust and personal understanding matter tremendously. And once that was established, I could then become more self-assured and say, well, thanks a lot for the invitation, but I also want to get something out of it. I'm not just here to explain to you how the GDPR works. I want to have a research question that I want to answer. I want to have resources for that. And that then eventually happened. So that would be, I think, my advice. Be willing to accept at the starting position a informatics-led, much better research-funded project, even though your role as a lawyer is probably more as a service provider. but show the people that you can be taken serious as a researcher and then treat that as a stepping stone. So for me, I think that would still be the way to do it.
Yeah, thank you. Thank you. Thank you, Professor Schafer. This was quite helpful and fun. And thank you, the Max Weber program, for enabling this. Yeah.
Thank you.
Thank you.
Thanks a lot.
Thank you.